Hello, Ursula.
Hello.
Oh, there we go.
Hi, Ursula. I'm the IT manager here at Fox Hill. I just want to make sure you can hear us.
I can. I was actually going to compliment you on that. Normally, when I've been set up like this, everyone's sort of yelling and I can't hear anybody, but the microphones are great.
Okay, good. Thank you.
Sure.
We've just been very well fed so that we'll go
Joe,
to
is this
sleep
Peter's
shortly.
phone? Oh, okay. Thanks.
Well, I'm definitely bummed I can't be there with you all, but the good news is 3.5 hours from now, I'm getting my first shot of the vaccine.
Which one are you getting?
Pfizer.
Good.
That's
Yeah.
what most of us had.
Yeah, we're really, my husband and I both got an email, surprisingly, because we don't have any underlying health conditions or anything, but apparently FEMA gave the city of Alexandria a very large grant, like $1.4 million. And they said they were going to use it all just to buy doses. So a ton of my friends that live in the city all got emails about the same time we did. So I anticipate potentially even running into friends and neighbors while we're in line this afternoon. So.
Ursula has a brand new house that she just moved into last week. And
We like the
last time
decor.
I left her, she couldn't find her jeans.
I still have not found those jeans.
You haven't?
Instead, no, but I found a bin that had a sweater in it that has been with us the entire time we've been in the apartment. And I never looked in that bin, thinking there were other things in the bin. And so the excitement over finding a sweater that I haven't seen in 18 months far eclipsed my annoyance over losing a pair of jeans somewhere in the house. So we'll see. My goal this weekend is to find the jeans. They've got to be somewhere. So
You find them by looking for something else.
correct. And that's and we have to get a little more organized. Everything's put away, but where that away is sort of iffy at this point. So I feel like I need to spend some time getting myself organized. And clearly I need some artwork and items in my office here to make it a little more interesting than the grayish walls that actually make me look even more pale than I already am. So I need to deal with that probably this weekend as well.
Well, I was on a conference call this morning with someone else who had just moved. And what we mostly were treated to was seeing her workmen hanging lights right behind her, that you'd see her and then suddenly you'd see this hand coming up and a chandelier being installed and stuff.
That's funny. Yeah, this is the first day. We moved in on the 4th. This is the first day that I don't have a bunch of contractors in the house. It's refreshing to actually not have a bunch of people here. I'm just used to coming down the stairs in the morning and somebody already being here that my husband has let in. So I think the rain's probably keeping some of that away because I know there's some more work to be done, but it's definitely nice to be able to enjoy the house a little bit and not have to worry about people coming in here and doing things all day. So that is nice today.
I think you've met most of the people on the board. Have you met Carla Shipley?
I don't think
I
we
have not.
Hi, I'm Carla Ursula. Nice to meet you.
Nice to meet you too. I'm glad you could join us today.
Thank you.
I always feel like, and I know this sounds a little kumbaya-ish, but really the success of an association really lies with all the different members of the team. And that includes your professionals, it includes your management team, it includes the board, it includes your committees, it includes to some degree your residents. And so I'm really glad you could be here today because I feel like all of us are working towards the same common goal. And it's always
Absolutely.
good to be on the same page.
Absolutely.
So good. Did you all want me to get started?
Let's do it.
Okay. So I'm going to share my screen. I will email you this PowerPoint after the fact. I intentionally did not email it to you ahead of time because I want you to pay attention to the PowerPoint. And I find if I give it ahead of time, people will jump ahead. I will have some additional items that I'm going to send you as well, some articles that I think are helpful, some information about Robert's rules, basically some standard items that I provide anytime I do a board training. So I will email a package to Brent after this, maybe after I get my shot, and then she can disseminate that to all of you. Oh, I don't have the ability to share my screen. Can Joe come back and help us out with that?
We have someone here that can do that right now.
Oh, great.
Do you want to try again now?
I got it. Okay, so does everybody see a slide that says Fox Hill Residential Condominium Unit Owners Association orientation?
Yes.
Oh, wait, let me ask you this. Do you see a different slide now?
Yes.
Okay, good. Okay, so our goal today is to give you all some tools to be successful directors. We have some broad topics that we're going to go through. And, you know, the one thing I want to impress upon all of you is this is for your benefit. And so if I say something or it jogs something and you want to ask me about it, please interrupt me and ask me. I definitely want you to get a benefit out of this. And frankly, I could talk for days about community associations and what needs to be done. And so I want to make sure that you get the most out of it. Even if we go off a slide, I don't care. If it's something that's productive and helpful for you all, that is a-okay in my book. So what I'd like to do is I've only met a few of you. And so what I'd like to do is have you all go around, tell me who you are, tell me if you've ever served on the board of a community association previously, why you are on the board now, and what you were hoping to get out of today. And Carla, I know that some of this doesn't apply to you, but if you want to talk about your past experience before being here and then what you're hoping to get out of today, that would be great.
Sure. Would you like me to start?
Absolutely.
Sure. So I actually have served on a board at my children's school when they were in K through 8 school. I served on their board. I've been with Sunrise 14 years. It'll be 15 years in July. Prior to that, when I worked for Genesis and was running a nursing home, I actually reported to a board there, and that was a great thing. And then with the other communities that I've worked in that are similar to Fox Hill, worked very hand in hand with the boards of both of those communities as well. One a CCRC and then one a condo ownership like Fox Hill has here. And well, I'm not on the board, but I'm here to help the board, support the board. And I guess just a better understanding and making sure that we're all on the same page is what I am expecting for today.
Great. And who's next?
I'll just go through, so we start the round. I'm Bruce Wolf. We've met on the phone a bunch of times. I'm not currently on the board, but I was previously on the board here. Stepped off because so that I could do more intermittent involvement, and which is all I have at the moment. And I'm here today in order to help kind of make a smooth transition for legal counsel to you, Ursula, from the stuff that I was doing previously without
Great.
license.
I'm Marilyn Moon, and I've just been on the board for about 3 months, but I've served on a number of other boards, mostly professional boards, nonprofits and things of that sort. And I'm an economist by training and interested in financial stuff. So I became interested in the financial committee, and that got me more interested in being on the board in general. And I guess my goal was to try to give something back, especially now when I'm relatively healthy and sitting around not being able to travel. So
And I miss travel as well. Well, good. Welcome to the board.
I'm June Ensign, and I have been on the board since its inception. Actually started with it when I was a council back in 2010. The only other board, homeowners board I've been on is back in the 60s in the original community we lived in. I've just been interested mainly in the buildings and the grounds and wanted to be active in the community, and that's why I joined the board. And I'm just hoping for lessons and clarifications of how you do things and whose responsibilities are what.
Great.
Hi, Ursula and everyone. I'm Jean McMillan. I have never been on the board of a community association. But when I arrived here, I studied the way things were going, and I read the documents and I read the minutes of all the committee meetings from 2008 to 2015. I have been on a lot of boards, mainly like Maryland Professional, Literary, broader community. I worked for 55 years, and I always wanted to be in a leadership position. I wasn't always the biggest boss, but I wanted to be sort of in charge, because I think I have the skills to do that. And I am always, from the beginning of my life, have been promoting the quality of life for women and children. One of the other things I've done is a lot of grassroots organizing. And the first thing we always do is get educated. So what I'm hoping to do today is hear from a different perspective to advance my education to be a better board member.
Great.
I'm Brent Gu. You've seen a good bit of me before. I've never been on a board before. I've had a lot of volunteer experience doing things, but not on board. And I'm looking forward to learning everything I possibly can today.
Great.
Hi, Ursula. I think we met before. My name is Don Coleman. This is my first condo or homeowners board. My previous board experience has always been with professional boards and that ilk. I joined the board sort of serendipitously because I was with a friend I met at Fox Hill, and they suggested I would be a good candidate, and I fell into it. So it was no deep thought. I'm here because often I don't have a clue of what the board should be doing. So I hope to come out of it a better board member.
Great. You've been, the way you got on the board is we refer to being voluntold. Somebody just stuck you on there and off you go.
Hi, I'm Jack Jacobson. We have met once before electronically. I'm the 7th member of the board. I would guess I've only been on it for 3 months. I would define myself at this point as a utility player on the board. And I joined the board partly because there was an opening and they needed somebody, and partly because I get a lot out of this community, so it's good to give something back. I've had considerable experience on commercial, corporate kinds of boards. I have been on one in Newton, Massachusetts City Commission that's dealt with a bunch of issues in that city. So I have some experience of that kind of community issue.
Great. That'll be helpful.
Hi, Ursula. Good seeing you again. Jack Cypress. We've
Hi,
met,
Jack.
spoken a number of times. With respect to Fox Hill, I've been here since almost the beginning. I was instrumental in organizing the informal group that we had before we actually became the board. I chaired that until we did become the board. And then I chaired the board for a couple of years. Outside of Fox Hill, served on various committees and chaired various committees in professional organization that I'm part of. I was also chairman of the Homedale, New Jersey Planning Board for a number of years. And professionally, I was basically most of my career was as a project manager on some major projects, which involved large committees. And I'm here to learn about all the things I did wrong all these years.
Well, I mean, I guess that's a good dose of honesty there. And that, by my counting, and that puts us at 7 board members, Bruce and Carla. Is that everybody in the room?
Yep.
And one tech guy.
And 1 tech guy. Tech guy, did you want to tell us about yourself?
He says no, thank you.
Okay, so you can see what's interesting is, you know, you all are fairly standard as far as a board. You come from different backgrounds. While a number of you have served in other professional boards and other capacities, you have different strengths and backgrounds, like being an attorney, financial, project manager, overall leadership. And then those of you who just simply got voluntold into a position, which I always think is a natural struggle for community associations, because the only thing that you all have to have in common to be on the board is that you own property within a geographical area. And so it can often make a board operation a bit of a struggle. If you have a board that's just full of lawyers, which I have a few of those, or a board that's just full of librarians, because everyone's got different strengths and different weaknesses, and there's no building the board based on those strengths and weaknesses. So it's really important in my mind, since you weren't put together cohesively or with any intention, that you understand what your roles are so that you can take those skills and use them to govern. So I know most of you have not met me, and so I thought I'd maybe tell you a little bit about myself. I have been practicing law since 1999. Before I did this, I did criminal defense for about 5 years. That was interesting. I have lots of unfortunate stories of very creative criminals out there. And then I started at Reese Broom in January of 2004 and have been here ever since. I'm an equity partner in the firm. I would say 98% of my practice is community associations in Maryland and Virginia. I occasionally dabble on weird stuff, largely because of the criminal defense background. I've had to meet with detectives when clients have had embezzlement issues with employees, and call the jail when we have somebody who's supposed to be in court to see if in fact they are in the jail. It's interesting, but this is really all that I do. I am a member of the Community Associations Institute, and actually I'm just finished last year my year as president of the international organization. So I'm very active in keeping up my education as well as an attorney in community associations. I teach regularly, I speak regularly. And so I really have a lot of experience with community associations and the issues that you're going to face. With that said, my firm also has 24 additional lawyers that just do community association law. So 99% of the time, an issue that a client is facing is often an issue that other clients are facing. And so we meet regularly to talk about trends and things of that variety, especially with all the COVID changes that we had in ramping up this time last year. And now as we're starting to ramp back out again, we're continuing to be involved with that. So I have a lot of experience. It doesn't mean that I am not open to ideas and thoughts on things that you all want to proceed, even if it's different from what I'm recommending that you do. I like new ideas. I like thinking outside the box. So I'm always going to want to encourage that from you all. But just want to give you that background so that you understand that I am coming from someplace that community associations basically are my life. Not the most exciting thing on the planet, but it's very helpful for clients. There are some items about community associations that are common for all of them. Key is mandatory membership, right? We've all been members of recreation associations, boat clubs, things of that variety, where we have elected to join something and it's not mandatory. Here, you own the property within the confines of the association, you are a member, period. You also have the power to regulate and the power to assess. There is some interesting case law a number of years ago.
Ursula, you may want to hold up for a moment. We're not getting your slides.
Oh,
Yeah.
Sorry about that. You just went away.
We just have a tiny little picture, maybe of you up on the screen that if our eyes were better, we might be able to see it.
oh, yeah, you're just getting the view instead of the screen, you're getting the view of the attendees.
Exactly.
Yep.
You know, we've got the Microsoft Foursquare blank.
Yeah, it's so easy to toggle that on Zoom if you're not paying attention to not only decrease your entire screen, but then get to the point that I've actually lost what was going on with the window.
He was just on that third screen. I think when she switched slides, that's when it flipped off.
Okay, we're back in business.
And now you can see the slide?
Yes.
Yes.
With a green
Great.
stripe on the left, yeah.
That's it. So this is just the list of the items that are the basics of community associations. And this is common to all of them, whether you're a co-op, a condominium association, or a planned unit development, HOA or POA, depending on your terminology. So your sources and limitations of authority are very important. And community associations exist as a result of statutes. They are not something that are just came out of the ground and could exist. They are heavily regulated by federal, state, and local laws. So the one thing that you're going to need to keep in mind is that whatever you do in your regular life, that doesn't necessarily mean that's acceptable and permitted to be done under this context. So I've had a lot of board members get very frustrated about not being able to do conference calls, which we're going to talk about that in a bit, to accomplish things, because they say, well, I do that in my job all the time. And so the answer is, well, what you did in your job or you currently do in your job does not necessarily apply here because of the heavy regulation. You're regulated essentially by three sort of big groups. Statutes, which include state statutes, local ordinances and orders, and federal law. Your governing documents, which are viewed by the courts as contractual documents between you and the unit owners, and then case law. And that includes, to some degree, the CCOC opinions. You know, I served as a panel chair for the CCOC for a number of years, and unfortunately, the opinions oftentimes don't go into a great deal of analysis on case law and how it applies, but they can be helpful at times when we hit a situation and we think that we might end up in front of a judge or the CCOC. So they are something that we do go back and look at when we have an issue that comes up for a client in Montgomery County. The asterisks by the statutes and the case law, they can change without your knowledge or control. The good news is we have a colleague in the office who's actually a delegate in the Maryland General Assembly. So we get very good information from her, as well as another colleague serves on a legislative action committee that actually lobbies the Maryland General Assembly members and actively pursues, supports, and opposes legislation on behalf of community associations. So we get good information from them. And with so many attorneys in our office, when any new case law comes down, we all tend to jump all over it and try to get an alert out to our clients. So you will see, if you haven't poked around on our website, which the last slide here will have that information on there, we have lots of memos and alerts and things to clients over the years that you can look at for free that show you when something like this hits. We try to get an alert out to everyone to understand it. The most recent one I can think of that was very impactful in Maryland as far as a case was the holding that pit bulls were per se violent. And it held a requirement that if a pit bull injured someone on property, the property owner was strictly liable for the damages caused by the pit bull. It was a terrible case. It caused a lot of problems across the board, as you might imagine. I mean, imagine sitting in a vet waiting room and a dog attacks another dog. The vet was now going to be responsible for that. And they ultimately dealt with that legislatively. But when the case came out, we had to alert everybody about that so that our community associations were aware that this liability existed. Thankfully, it was for a fairly short period of time, but it was still there. So my job is to help keep you all updated on that as much as possible. Questions about that? Okay.
Just one question, Ursula.
Sure.
How active are there lobby groups lobbying to influence the condo association laws? I mean, for example, the limitation on the $10,000 deductibility to a homeowner. How much is that an influence, say, of the insurance lobbying game?
So that particular statute was heavily supported and pushed by the Legislative Action Committee put together by the Community Associations Institute. And we worked together with insurance professionals on it over a number of years. So originally, the insurance professionals, who many of them are members of CAI and active in CAI, didn't think that we needed to move the deductible up to $10,000. But as we continue to see these losses occur and continue to see the premiums go up and the community associations losing a great deal of money over these losses, they finally came around a couple years ago and said, we can support this. So the driving force was the Community Associations Institute, but we had support that we've been garnering over years from the insurance group as well. And so that's ultimately what pushed it through. So it depends on what the law is, right? Currently, there's a bill pending about reserve studies in the General Assembly that passed the House and is now headed to the Senate. The Community Associations Institute opposes the current way that the law is written because it requires full funding of the reserve funds to match the reserve study. And as you all know, items can fail sooner than expected or later than expected, and you really should be given the flexibility to fund your reserves in a manner appropriate to how your community is working. So we're waiting to see what happens with that, but my guess is when it hits committee in the Senate, we will be sending out alerts to people to say, we oppose it and here's why. It requires a regular reserve study, which I think we all support. I think it's every 5 years. And I think that a regular reserve study is something that is essential to good budgeting for a community association anyway. But that law, and I'm not sure who's actually backing that and pushing it. It would not surprise me if that's a financial group that's pushing that more. Because if we have to have higher reserves, that means the financial institutions have more money of ours invested with them. That was a long answer. Sorry about that.
Thank you.
Sure. So Article 3, Section 3.1 of your bylaws has this language. I'm not going to read it to you. I can tell you this language is common. I have another association that was built in 1987, and the language they have is identical to this. And it's very broad, stating that you have all of these powers and duties. And as you can see, there's asterisks by it. And that's because it's a lie. You do not have all the powers and duties that are not prohibited by the act or the instruments. You only have the powers and duties that are in your governing documents. And that has been a consistent ruling by the courts. So while I appreciate that the attorneys that draft the documents put that broad language in there, it's not true. So you need to be aware of that if you find yourself taking action and you say, well, it's not prohibited in the governing documents or the act, and this says we have all the powers and duties necessary for this, you should take a step back and evaluate what it is that you're doing, because this broad language may not get you where you need to go. The other language that's interesting in that section is the requirement that the board shall delegate to one of its members, or apparently some random third party, to work with management in between board meetings. And so because you have that shall language in there, that's something that you all need to consider, and need to consider, for example, how often do you want to appoint that person? Is it something that you want to do annually? Is it something that you would like to do more frequently, biannually, quarterly? And in evaluating that, you need to consider more than the officer positions. So many of my clients have a knee-jerk response that the president should be the person that is the liaison. But oftentimes the president has a lot of things that he or she is doing, and really it would be better for somebody who's got a bit more free time to take that up. And how much authority that delegee has is up to the board. So that's why I included this quote, that you can delegate authority, but not responsibility, because ultimately the actions of the board are through the board and not through the delegee. Questions about that?
Could you give us some examples of the kinds of things that that might entail? Because that would presumably impact who would be given that responsibility.
That's a great question. And it can be, I mean, maybe the best person to give you that example is Carla, as to what sort of things that she has that comes up in between board meetings that she needs some direction from.
I think COVID's been a great example of that, because between board meetings, we all talk at least once a week on what do we need to do to operate and change. And so I think the way that I read this is that it doesn't necessarily have to be the whole board, but it could be one member of the board that's working with us on, what does the reopening plan for COVID look like? Would that make sense, Ursula?
It would, although a reopening plan, obviously we want the full board to ultimately approve it. But certainly, I can think of things like, say you've got a carpet that's failed, and Carla wants to know, well, should I get a quote to just replace this carpet in this hallway? Or do you think it's worthwhile for me to get a quote to replace all the carpets so it's all the same because this dye lot's not going to match, so forth and so on? That liaison could give you some direction perhaps on what sort of quotes to get to bring then to the next board meeting, so that people know we'll have those options then to review.
So it might make sense to have more than one liaison, for example. maybe it makes sense to have a buildings and grounds liaison, or for some of the most common stuff, and then somebody else for miscellaneous, let's say.
Sure, that's not a bad idea. And then that way you've got a little bit of division anyway of labor, and somebody who's focused only on certain things, which would give you some continuity and the ability to address those items in a timely manner.
Ursula, could you talk a minute about this language presupposes action between board meetings? which raises in my mind two questions. Number one, is it supposed to be actions that can be completed or that need to be effectuated right now before the next board meeting? Or does it involve making decisions that have a tail that goes beyond the next board meeting?
So I think that's a great question. And that's actually something that you all would need to decide, right? So your delegation to somebody is driven completely by what the board empowers that person to do. So for example, in Carla's example about COVID, she may have a liaison to talk to if a staff member or a contractor in the building contacts us and says that he or she had COVID while they were on site. What should we do next? And then the larger discussion of, well, what should we be doing overall? Should we be setting more requirements about contractors in the building? Did this person get screened? Do we have a screening procedure? That would be something potentially the board would take up. But in the meantime, the delegee would advise Carla on the immediate steps to take to address that issue.
Ursula, as you go through this, it might be useful if you could comment and help us in some of the constraints that are put upon us because of the structure we have here. As an example, the COVID example is basically an amenities issue, which the board has no responsibility for or authority over. So in going through this, you're familiar now with the structure we have here. You might want to alert us to some of the issues that may come up as a result of that.
I will, to the extent that they are apparent to me sort of immediately. This is more of a higher level kind of conversation about governance. And certainly the question of COVID, I mean, you could have somebody who visited an owner and we subsequently learned that they had COVID, right? So that wouldn't be an amenity issue. That would be, there was somebody on our property that had COVID. How do we address it? So, you know, we're sort of talking in generalities here about examples on the delegation. So the delegation needs to be something that's meaningful so that the delegee is giving correct direction to Carla based on the consensus of the board that he or she is already aware of, and then can alert the board to what's going on so that you can address longer standing or policy issues at the board meeting.
Ursula, my request wasn't basically on the delegation. It's in general, as you go through this education for us, if you can alert us to some of the issues that we have to deal with as a result of the structure.
Again, I will to the extent that they have some bearing on the governance, but as you'll see, these slides really talk more about your governing documents and duties as fiduciaries. And so it's a little bit less down in the weeds and a little bit more up on the high level. But to the extent there's something that you have a question related to that, we certainly can explore it at that point.
Ursula,
Yes.
on this shall delegate, I think the implication is that if you, in this case, interact with Carla, and it's an issue that could affect the board's responsibilities, you need to have the delegation. You cannot just informally work with Carla on an issue where you require delegation, formal delegation from the board to do that. I assume if you were to interact with Carla on some issue that you're trying to get done, and it's an issue that is relevant to the board, if you do that without the delegation from the board, then, so to speak, you're out of order.
I would agree with that.
Yeah.
It's one of the things that I hear from my managers. I've just met Carla, so I've not heard this from her, is getting direction from 7 different directors on 7 different things that all 7 of them think are important can be extremely time consuming and frustrating for the manager. Having the delegation is really meant to give your manager peace of mind of who she needs to go to if she's got a question, and to know what the expectations are as far as people who may be coming to her. Now, this language about the delegation is related, is in your bylaws and is only related to actions in between meetings. You certainly can do additional delegations, right? You could delegate to the treasurer to work with Carla on developing a budget for, redoing, for example, just the interior of the building, right? That treasurer could be tasked with, go sit down with Carla, spend some time on that and come back to us on it. But not so far as go sign contracts and make these decisions. And so that way it's clear what the delegation is and what people are doing.
Does this mean that for our standing committees, it makes sense to have specific indications of what is delegated to them to do, as opposed to having it be just sort of you report back to the board?
Absolutely. In fact, there's a slide. I'm going to try not to make you all get sick here, but I have a slide on committees, right? Committees serve at the discretion of the board. They are there to make recommendations, and then the board, it's up to the board to decide what they do or do not want to do. But they should have a charter that outlines the responsibilities and the expectations of the committee. So, for example, I've had committees, social committees, that have authorized expenditures for events where they didn't have the authority to do it. And the argument that the committee had was, well, you all told us that we had to plan these events, and there's nothing in writing that says we can't spend money on it. So putting in a charter where you set out everyone's responsibilities and expectations and limitations is a good idea, especially if your committees are active. One of the other complaints I get about committees is that they will come to a board meeting, make a report, and make a request of the board at the meeting without submitting anything in advance for the board to review. And so in a charter, you could set forth some guidelines for the committee to follow, in that they need to submit items for the board to review at least X number of days before the board meeting, so that you all are prepared and it's on the agenda. Good question.
So in our case, I believe each of the committees has, I'm not sure we have, they all have a formal charter. They may or may not, I don't know. But it strikes me that most, at least, of the committee chairs are meeting with Carla on issues that are relevant to their committee. And it's not clear we have a formal delegation from the board. We may, I have it in my case, but I don't know if other committee leaders have formal delegation from the board to interact with Carla on these matters. That may be something.
Ursula,
we
could
need
you go
look
back to
at.
the slide that you were talking from before? 'Cause to Jack's point, there's a point I wanted to ask you about. This is a delegation for purposes of authority to act on behalf of the board. I mean, I could read that to say, we're not making eunuchs of board members. They still have an ability to give individual opinions and suggestions to Carla and do other things in the community. This is a question of delegating the authority to act on behalf of the board in making and having those interactions. Would you disagree?
No, I agree with you. I mean, the very specific language here says that it's the authority to act on behalf of the board on matters relating to the duties of the managing agent. So if Carla needs some direction on what it is that she's doing, she needs to have a person that she can go to for that. But you're right, it does not remove the overall responsibility or authority of the board, right? That's from that quote. You're literally trying to, I mean, literally the purpose of this is to make Carla's life easier, that she has somebody that she can go to get some direction without having to wait for the full board to make a decision, because we're going to talk about that in a minute. If it's outside of a meeting, the full board has to agree to something unanimously, and you can't really have a discussion about it. So this actually is sort of a workaround to be able to continue to move forward without the full board having to approve everything.
I think it's also implicitly, is it not, a way of saying that the president may or may not have that kind of authority?
Correct. And it doesn't even have to be a board member. It says to one of its members or a person employed for such purpose, which is extremely strange, but that's what the language says, that they have the ability then to act on behalf of the board with management.
If I have a nephew who needs a job, I could push for that, right?
We could appoint any number of people to do this.
Correct.
So on each subject matter, if we have someone we consider experienced, we could appoint that person to.
Correct.
I think someone mentioned it. I forget who said this. Maybe it was you, Jack, that talked about that. That's exactly what we're doing. Is many times the subject matter experts and the committee chairs are having conversations with me, sometimes with more than one board member or just the two of us alone, about something that is from within the committee. I'm trying to think of maybe IT, and when Brent, Don, and I met a few weeks ago about the web page and its functioning, that I think is an example of what
Yeah.
this would be. What I'm understanding Ursula to say is that there has to be a statement if you're going to have the chairs doing that, which I don't have a problem with having, multiple people to talk to. Then it just has to be an official delegation of
But we
authority.
need to make a formal statement that
Mhm.
that person is responsible for that area.
Has the ability and the authority to act on behalf of the board in such matters relating to the managing agent, I think is probably, I don't know, Ursula, I'm guessing that's what needs to be the statement giving official delegation responsibility to those people.
I do think you can do that, but you can also go through section 3.2 that lists a number of different items that you're supposed to be handling, and you could detail different delegees for each one. But I do think that it's important that it is noted somewhere, whether it's a resolution, whether it's in the minutes, because that protects people. If, say, somebody is a liaison and speaks to Carla and says, go do this, and a unit owner is upset about that and says that board member didn't have the authority to do it, you would be able to show that person, yes, in fact, that person had the authority to work with Carla to make the decision on this matter in between meetings. It's really a protective shield for both that director who's got the delegation and for Carla.
I have a question, Ursula. Certainly the chairs of the committees speak with Carla. Carla can come to us for discussion and analysis of problems, but you're actually talking about making a decision that doesn't come to the board. Is that correct?
So that's what the language says, yes, that is to act on behalf of the board.
Just as an example of this actually happening, at the last board meeting, Jack Cyprus had suggested that in order for me to interact with Carla around some insurance issues, I need to get formal authorization from the board, which the board then did. And I think that's an example of what you're talking about.
Yes, I would agree with that.
Yeah.
Okay. So you have certain duties. The duties of directors come out of a variety of places, including case law, because you are directors of an organization. You have to comply with these items, and a lot of them are fairly obvious. You need to attend the meetings. You need to read your board package prior to the meeting. You need to have some familiarity with the governing documents. I don't expect you to memorize them, and I don't expect you to necessarily try to interpret them if you think there's something that's a little gray there. And that's what you use your management team, legal counsel, and consultants to help you out with some of those items. But you definitely have to make some effort and be engaged. I think that's sort of a minimum requirement, I would say. I had a very disappointing meeting yesterday with a board who asked me to redline their declaration and bylaws. They're very old documents. They're from the 60s. And I spent, as you might imagine, a fair amount of time doing that. And in the first 10 minutes of our meeting yesterday to go through these line by line, a director said, well, what happens once we approve these amendments? Like, do they just go into effect? And I said, no, you have to have these approved by 67% of your members. And he literally started to laugh and said, well, there's no way we're going to get that. And I thought, you weren't even aware that this process involves getting your members to approve it, and you're not even engaged enough to know that. And then a second board member told me that she hadn't reviewed any of the amendments to the documents, despite them going out twice and being revised, and despite the fact that she's an original owner and has the best institutional knowledge for this. They were essentially unprepared for the meeting. And we didn't get very far, as you might imagine, after 2 hours. And I think they realized that they need to focus on it a bit more. So hopefully they will. So I don't get any sense that any of you are doing that. What limited interaction I've had with the full board has certainly showed me that you all are very much engaged and you care about it. And I mean, Bruce is here and he's not even on the board anymore. So I don't have a sense that that's occurring here, but it is important that you be engaged and you try to make the best decisions related to that by exercising the care and skill of an ordinarily prudent director.
I have a question, Ursula.
Sure.
And I'm not sure where the bylaws are on this, but I have the impression that there are many activities going on in the board where the board member is performing an operating role versus a governing role. And are we in, and this operating role then ultimately results in actions being taken that probably find their way into Carla's domain ultimately. And the question is, are we really empowered to do that, or is it in conflict with our arm's length governing requirements?
That is a great question. And the answer to that question is not simple. So there's nothing that prohibits the board from being involved in operations. I certainly have board presidents that draft the annual meeting notices and the proxies and send them to me, and I revise them. I have other associations where the entire annual meeting is run by the management team, that they draft the initial notices. They're certainly sent around the board for them to review, but they review the notices and send them out, and not the board members. So the key is, how can you operate in a way that allows you to get all of the work done that needs to be done for the association in a manner that is in full compliance with the governing documents and the law, and is effective, right? So if the board is heading into operational sides of things, and you're finding that board members are getting burnt out because they're spending a lot of time doing that, and the board meetings are very long because they're getting into operations, that to me is an indicator that it's not working very well. Usually when I get that hint, I start poking around to see if there are operational items that the board is doing that are really on management's plate in light of the management contract, right? You have an agreement with management on things that they do. So my personal preference is I prefer for the board to stay out of the operation. I think it's cleaner. I think policy governance is a better model for community association boards, but I respect the fact that policy governance is often too hands-off for boards when you're talking about your home and where you live and your neighbors and all of that, which tends to be more on the emotional side. So you can do it, but you've got to find the right balance so that the board members aren't getting burnt out. Everything's being done that needs to get done. Your manager isn't running screaming from the building every day because management's doing things the board's doing things that management's unaware of, which I've certainly seen boards that have done that. And so you all have to sort of work together as a team to figure out what works best for you.
Okay.
So, I mean, you're going to find one of the neat things about community associations is while you are heavily regulated as far as powers and things of that variety, you all have the freedom to figure out the best way to effectuate that, whether it's how much operational items the board does, or how much you delegate to particular board members, or whether you want to follow a more hands-off policy governance model, as opposed to, you know, a sort of a non-model of what most boards actually go by. It's simply a matter of, you know, sorting their way. It's really something that I always recommend that you have an annual planning session with your management team and open conversations about what's working, what's not working, what would you all like to see being done differently, and how do you figure out how to do that? And then you hit a nice balance, and then you have an election and you get new directors on the board, and we have to basically go through the same process again, because you get new directors on the board and have potentially a different point of view on how things should be done. And then you need to oftentimes sit right back down again and go through the process again.
Yes, I suspect that's a discussion we need to have. That's my opinion at this point, in a fashion that we haven't had. I may be wrong on this. I don't carry the history, but I don't have the impression we've had a discussion with Carla about, just where the boundary should be between what they're doing and what we're doing, so that there's an appropriate balance of getting the work done without conflicting with our governing responsibilities.
And, you know, it's a good conversation to have. It's a good conversation to have annually, in my opinion. I feel like I always recommend to my community association boards that they should have a planning session in the beginning of the year of their fiscal year to talk about what it is they want to accomplish over the year. And then they can either set milestones and revisit how they're doing at regular intervals during the year, or as a minimum, they should sit down together as a team at the end of the fiscal year and say, did we accomplish everything? If not, what was our impediment? What can we do better next year? And that's when you start having a good self-analysis of what have I done? What have we done well? And what do we need to improve? And how do we do it? And I think a lot of boards don't go through that. And I think that's unfortunate, because I feel like if we don't look back at what we've done over the past year that we didn't do well, we're not going to learn from that. And we're likely going to repeat the mistakes on upcoming projects and other items in the next year.
And I assume at some point you'll cover which of those kinds of things have to be done in an open meeting and which of those things are done in an executive session.
I am going to cover all of that. Thank you. You're like a mind reader today. I love it. Okay. So again, some standards for proper performance. You want to find precise and express authority for your actions. Like I said, if you're going back to that section 3.1 that says you can do whatever you want, you should put up a red flag and understand that. You need to relate your decisions to the association's purpose, and you need to understand the rules, refrain from arbitrary or capricious actions or enforcement, and you need to adopt policies properly and enforce them as uniformly as possible. And I understand that you all don't actually have a bunch of rules and regulations. So I wanted to run over this with you. Obviously, you don't need to memorize it, and it's in the slides. You will have it in writing, so you understand what the procedure is, and your bylaws state that rules have to be adopted this way. So it's a multi-level process. So you need to send all the unit owners a copy of the proposed rule. So that means if you're in a board meeting on January 15 and you say, I think we got to pass a rule that everybody's front door should be day glow yellow. And all the board members say, I agree, I think we should put that out so we can adopt it at our next meeting. You would then send a copy of the proposed rule to the unit owners. And in that notice, it should advise them that they are allowed to submit written comments on the proposed rule and what the proposed effective date is going to be of the new rule. You then have to hold an open meeting to allow any unit owner, and interestingly, or a tenant, to comment on the proposed rule. And the meeting, you must give notice at least 15 days before the meeting that the meeting is going to be held. And you need to have a quorum present at the meeting of the board. And then you all can vote on the meeting, on the rule at the meeting. So it gives everybody the opportunity to give the board feedback on the rule before you formally adopt it. And this procedure, while is a little bit more burdensome in that you can't simply adopt it at the meeting where you have the idea to do it, it puts everybody on notice in advance before the board adopts it. So a unit owner has less of an argument to say, well, I didn't know you were going to adopt this rule. And it gives unit owners the opportunity to provide comments to the board. And sometimes I've seen comments come in that have been very helpful on a rule. And the board then has revised the rule before adopting it at the meeting.
So could you go back a step for us? Because in fact, there were rules and regulations adopted. They're part of the condo docs that people get when they buy. They were established some time ago. Number one, I don't know what procedure was used to adopt them, but they were adopted. Secondly, I believe our bylaws provide that the rules and regulations can be amended by the board.
Correct. And this doesn't change that. What this says is you have to provide notice of the rule to the unit owners before you can adopt it.
Okay, so there's still a process by which the board can adopt new rules. They just have to notify the unit owner.
Correct. And you'll see in the bylaws, some of your bylaw language has been very helpful. Like the election language actually does have all of the language of the Maryland Condominium Act. Regarding rules, it simply says rules are to be adopted pursuant to section 11-111 of the Maryland Condominium Act.
Help me understand, what's a rule as opposed to a policy or operational decision?
That's a good question. My opinion is that a rule is something that governs the behavior or actions of any occupant or owner in the association. So a charter, for example, for a committee would not be a rule. That is an enabling document that sets up the parameters of a body working with the board. But if you set up a collections policy resolution that talks about when late notices are sent and things of that variety, that would be something that I believe would need to be pushed out to the unit owners before it could be adopted.
Regarding historical rules, which may or may not have conformed to this process, are they automatically grandfathered in, or could somebody challenge them by saying, demonstrate that you had used this process to put the rule in place?
It's a good question. If the rules were established by the developer, so sometimes we see that, we see rules that are just established at that point in time, along with the rest of the documents, then I don't think they have to go through this process, because at that point in time, there aren't any owners. But anything after that, they do need to follow the process. Do I think that there's probably a time limitation if you've had a rule in place for 7 or 8 years and no one has raised a concern about it? You know, I think that there's probably a limit on that. And I really think if someone were to challenge it, it would be on the side of the unit owner challenging it to say that we didn't follow the proper procedures. So, you know, would I be concerned about that? Yes, a little bit. Is it something that you should lose sleep over? No. But if you have rules and regulations that you ultimately want to revise that were adopted by prior boards, we could then ensure that we could amend and restate them, or do whatever language we could to ensure that the entire document then is properly sent out to the unit owners and adopted in compliance with the act.
A little bit of the history here. I suspect the rules and regulations were written by Bob Diamond, and they were adopted, quote unquote, I'm not sure actually adopted by the declarant, but they were put in the original condo documents that we received. And there's been no changes in those rules ever since Bob Diamond wrote them.
And if that's the case, they're fine, because at that point in time, it was the developer doing it, and all of that is set down and adopted prior to the conveyance of the first unit to a unit owner. So this procedure wouldn't kick in.
So this procedure would be for any new rules and regulations that the board would like to propose.
Correct. And that's why I wanted to make you all aware of it, since it was my understanding that you all hadn't done that. And so I just wanted you to be aware that there is a procedure you need to follow. Okay. So one of the other big issues that you all will face is the fact that you are a fiduciary, which I'm sure all of you have dealt with fiduciary duties before with your past experience on boards. And again, that just requires you act in the best interest of the association, disclose any personal interests that conflict with anything that you all may be doing, or any relationships you have with people that you might be working with. I tell the very famous and embarrassing story that when I was an associate, I went on a date with someone, a blind date, and it turns out he was the board president of one of our associations. And I immediately felt this compunction to go to the partner who was handling the clients, indicated that my date was a client, and what his thoughts were on it, and whether I, was wise for me to see him again. And what felt like an eternity later, when the partner stopped laughing at me, he told me that provided the client didn't fire us, I could date any board president of my choosing of all of our associations. It was not one of my better moments, but I felt that I needed to disclose that and figure out what was the best way to proceed on that, because at that point I was wearing a variety of hats. I subsequently went on a second date with him, met my husband, my now husband, after that second date, and promptly told the board president that I couldn't see him anymore, because once I met my husband, I was done. That would, I guess, would have been interesting had I married one of our board presidents down the road. So it's always important, disclose it. Disclosure is much better than any backlash of some perception of an impropriety or a conflict. And then obviously avoid disclosure of confidential information. And those are items that are in closed session, which we're going to talk about here in a moment, that you should not be talking about with others for the protection of privacy and for the good of the association. Do any of you have any questions about the fiduciary duty? My guess is most of you are probably already familiar with this. Okay. So the good news is if you follow all of this and you make the best possible decisions, you're going to be protected. There is specific language in section 3.11 of the bylaws. Protects you for any mistake of judgment, negligence, or otherwise, except for individual willful misconduct or bad faith. And you're covered by insurance. You've got directors and officers insurance, and potentially your general liability insurance may kick in depending on the source of the claim and what they're alleging. So we call this affectionately the true heart, weak mind defense. It means you meant well. You did everything that you thought was right, but you turned out to be wrong. And that's okay if that happens. You'll be protected and covered by the carrier. So you can act in good faith. I have board members who get on the board and become very nervous about potential liability for items, and you've got great documents for that. So it's something that you all should keep in mind. Where it doesn't kick in, obviously, is if you engage in really bad misconduct. We've had a few cases where we've had some defalcation by the treasurer of an association, for example, and they obviously were not covered by any insurance. And the criminal justice system kicked in to take care of that. So do any of you have questions about this? Because it's often something that people do worry about.
Ursula, I do have a question, which is the this express language covering indemnification for members of the Covenants Committee. Does that contain a negative implication that the other committee members are not
No,
indemnified? Because our liability policy at the moment expressly covers committee members.
correct. I actually thought that was really strange that it was specific to the Covenants Committee. And my guess is Bob stuck that in there because if there's going to be a committee member that's going to have an issue, it might be the Covenants Committee members, right? Because they're telling people what they can and cannot do. And so we probably put that in there thinking they're the most likely to get that. And we wanted people to be comfortable to be on the committee. But you're absolutely right. There's insurance coverage for every committee member and committee chair for any of these types of items. And so they would be covered as well, arguably, unless we saw something like willful misconduct or bad faith, which is probably an exclusion in the policy.
I
Sorry, Jack, go ahead.
I assume that pertains to official committee members and not unofficial committee members. Is that
So
correct?
what's an unofficial committee member?
Not appointed.
Well, then they're not a committee member?
They're not an official committee member, correct?
Well, then they're not a committee member.
Correct.
So, I mean, the answer is that is going to lie with your policy. So sometimes the policies are much broader and list not only committees specifically, but volunteers. So if you all were to have a bake sale and somebody volunteered to be at the table and somebody sued them because they bought a pie that made them sick, they would likely be covered under the DNO as a volunteer.
Okay.
If you have a committee member, a quote unquote unofficial committee member that does something outside of any sort of power that he or she has, I don't know that they would be covered. Because if they're acting outside of any authority they've been given under the committee charter, there may not be protection there.
So just a detail on insurance. Does general liability include fidelity insurance?
No, that is a
Each
separate coverage, correct.
So wouldn't one, as a source of protection, also need fidelity insurance?
Yes, and you have it.
Yeah,
Every
I know, I just
association
wanted
has
to
it.
be sure that that is a requirement for sources of protection.
Correct. This is limited to protection if you were sued personally as a director. The fidelity insurance wouldn't cover that. The fidelity insurance would cover the association, for example, if a director stole money from the association, then the fidelity insurance would kick in to make the association whole if need be. Thankfully, I've tangled with that only once, but when I tangled with it, a management company had emptied out a client's reserve account completely. It was to the tune of about $350,000. And it took some yelling eventually on my part, a number of letters. We had all the support we needed. We had bank records, and the insurance carrier kept hemming and hawing. And finally, I basically let the guy have it, that we'd given them everything and this was ridiculous and it needed to be covered. And within 48 hours, they received notice of coverage and a check to cover all of the funds that had been stolen.
Huh.
I hope I never have to go through that again in my career, because it was very stressful for the client. And yelling at an insurance representative is not high on my list of things I enjoy doing.
Ursula, with the coverage that we have for D&O, is that adequate for the board, do you think? Because there's been some conversation going back and forth about increasing that amount.
That's a good question. I don't know offhand what your policy limits are, but there are really good insurance brokers out there who have been in the industry for a gazillion years, who can actually tell you what reasonable limits are that they've seen that are across the board. I've had two clients sued, both in excess of millions of dollars. Both cases were ridiculous and both were dismissed. So I've never gotten to the point of the D&O never being sufficient.
So the broker recommended, it's Willis Towers Watson. And they're the ones that are kind of coming back and telling the board that the coverage, I think it's 2 million, is adequate for them.
I mean, 2 million's a good number for D&O. And I'm sure that would be more than adequate for your fidelity coverage, which needs to be a minimum of 3 months of assessments plus the balance of your reserve fund.
For clarification, can you does that D&O also include the committee members and committee chairs? Is
Yes.
that the same policy? Yeah.
Yes,
that
sir.
2 million is a lot, is really spread over a lot more entities than just the directors and officers.
Correct. So you sort of have to hope that we don't have a bunch of them do something bad at the same time.
So one of the things we're required to have is umbrella insurance, which I'm not sure we actually have at the moment as a co-insurer. But if in fact there isn't sufficient coverage in the D&O, would the umbrella coverage then kick in?
Usually where I've seen kick in was the general liability insurance is where I've seen coverage over it. Although it's certainly possible that I've had instances where there was umbrella coverage that was acting as backup. So it's really going to depend on how your policies are interrelated and what they each cover. And there certainly could be instances where the general liability would kick in over above it, and other instances where the umbrella would kick in over it. I think it just depends on the claim.
Okay, thanks.
Ursula, I think we also have some questions related to the D&O and general liability in terms of costs of defense, which are included within the cap of the D&O. So if you assume a massive litigation that is well funded on both sides, our numbers may or may not be sufficient. A, and B, there's also the question of what that limit is on. Is it only the RCA as an entity, or has Sunrise procured insurance that covers multiple entities with it's a cap of $2 million? Right. And that may be an issue that we have to address. Right.
So obviously I can't answer the second question. As far as the first question, I mean, that's a good point, but my hope is that based on, and this kind of goes back a bit to what Jack had mentioned, you all have some limitations on what you all actually handle and what you all are responsible for. My hope is that there wouldn't be something that would occur that your defense costs and potentially any award would reach $2 million. And in fact, you know, the litigation where I've seen that was bad. I think the worst litigation I've seen was against a homeowners association where a child fell into a stormwater maintenance pond, a wet pond, so it was constantly full, that had not been properly maintained. And the child was sucked down into the water where the grate was, where they were sucking the water, and was underwater long enough that the child was confined to a wheelchair for the rest of his life in a largely vegetative state. They appointed insurance defense counsel. The big issue turned on whose obligation it was to maintain a stormwater maintenance pond. There was a belief by the association that it was the county's obligation, and the county's belief was that it was the association's obligation. And in the end, the case was ultimately settled for the policy limits of the association. And I do believe that kicked into either general liability or umbrella as the secondary coverage, because it was a very large payout, but it was sufficient. And I don't know that I can think of a situation worse than that. And you all certainly don't have the infrastructure and the items of that variety that would lead to a very large claim like that. So my gut is that 2 million sounds about right, but you certainly can continue to ask that question. You can ask other brokers. You can certainly poke around on that. I just, based on your limited scope of what you do, I'm not getting the sense that 2 million is not enough. Okay. We've already talked about committees and meetings. Again, I don't have any feedback on how your meetings are going, so you can take this slide as sort of a reference. You know, the question I get all the time is, what is a meeting? If a quorum of the board is at the grocery store in the produce section and something comes up about the association, is that a meeting? And the answer to that is no. So a meeting is a gathering of the board to make decisions. So the CCOC kind of ferreted that out a number of years ago. I'm not sure that I necessarily agree with their analysis, but that's how they're approaching it. So if you all decide that you want to have, you know, a spitball session on something where you're not going to make any decisions, arguably that's not a meeting. I think the better practice is to let your members know that you're having these sort of spitball sessions, and that if they want to attend to hear you all discussing it, they are welcome to do that, but they are not allowed to participate in it. If you have meetings, you obviously need to have some time for the members to address you with questions. And if you find that that's taking too long, you might want to set some limits on open forum. For example, that people get 3 minutes to speak and everybody gets an opportunity to speak. And then the board may close that or set a time limit for the full open forum so that you all can move on to the rest of your agenda. That's something that you all are going to have to tweak depending on what your residents are doing at these meetings. Some associations I go to, the residents come to the very beginning of the meeting and all of them leave after they make their comments. And others, they have a very large group that attends, they have a very long owners forum, and they often will do a second owners forum at the end to address anything that people didn't get a chance to talk about at the beginning. So that's again up to you all and how you want to handle that depending on how they're going. We recommend that you strive to have meetings that are no longer than 2 hours. People start to fade after 2 hours. And so if you have a big topic on something, have a special meeting on that one topic. Use committees to assist you. The example here is we say thresholds for collections issues. That's if you're having collections issues and it's tying up a bunch of your time, you know, give us some authority to accept payment plans of a certain variety. Really, if you're having meetings that are longer than 2 hours, we need to have a conversation about that. So talk to me. Are you all having extra long meetings? Do you feel like you're not meeting enough? Do you meeting too much?
No, none of our meetings have been extra long. Generally, our open board meetings are 1 hour. And then we've had some executive session meetings, but they've never gone over an hour to my knowledge.
Good. That's good to hear. Keep that up. I like it. So here is our slide on what you can discuss in closed session. And again, I'm not going to read it to you because I'm going to email this slide to you. What I recommend, and it's actually 2 slides. What I always recommend is that you print this out and that your secretary under this part here, B2, because you have to have a statement of the time, place, and purpose of the executive session, is have your secretary print it out and then they check the box of which one of these items they are going to be discussing in closed session. And that way it's a check, because if the secretary says, I'm sorry, there's nothing on this list that meets this, then you should back up and contemplate whether in fact it's something that you should be discussing in closed session or not. Questions? Okay. Action outside of a meeting. This is another very common question that we get. You have language in your
Ursula,
bylaws.
Let me go
Yes.
back to the previous slide. Is it sufficient for the minutes simply to say the following was discussed, period?
No. If you make a decision in closed session,
No, assuming no decisions.
if no decisions, then your minute should say 7:15 p.m. motion to go into executive session to discuss matters pertaining to employees and personnel. The next thing should say 7:30 p.m. exit out of closed session into open session, motion to adjourn. So minutes are really kept just to keep your decisions. And so if you don't make any decisions, then I don't think there's really any minutes that you're keeping aside from the fact that you went into it and came out. Does that make sense?
When you have an executive session for something that's confidential and you're supposed to reflect the decision, how do you keep that private, or, you're going to put it with the minutes?
That's a great question. The way this is written, you can keep minutes of the executive session so that you as a board know what decisions were made, but they aren't given out to the members or kept with the minutes of the open session. So you see in this language here at the bottom, it says that the minutes aren't subject to disclosure unless a majority of a quorum of the board of directors approves unsealing the minutes or the recording of the minutes. So they're really just meant to keep you all remembering what it was that you decided in these closed sessions. It's not meant to be something disseminated to the owners, which is interesting because in Virginia, you actually can't make decisions in closed session. You have to come out of closed session and have the motion and vote in open session. And there are very awkward motions made because you're trying to protect privacy and other concerns, but yet have a record of your action.
So we can have just a little book of executive session minutes.
Correct. And you should. That way you have a record of the decisions that you're making in executive session. Okay. Action outside of a meeting. So this is again from section 3.8. Again, it's identical to language that I've seen in other documents. And it states you can take an action outside of a meeting if all of the directors shall individually or collectively consent in writing to such action. So we're going to drill this down a bit. It's an action. It's not a discussion, right? So what does that mean? It means if Brent says an email that says, I spoke with Carla this morning. We have an issue with this item. She can't authorize spending for it because it exceeds the amount that she's able to spend without board approval. And here's the quote, and we need to take this action. Do you all approve this contract? And the emails back should be approve, 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 approve. It cannot be a reply all with, wait, Brent, I don't understand why we're doing this. This doesn't make any sense. This should have been fixed, X, Y, and Z when they did this other work, so that it becomes a discussion. When it becomes a discussion, now it has the appearance of being a meeting, right? So we talked about what is a meeting. When the board is having a set time to talk about stuff and make decisions. And we've had some court opinions that say when people get in these lengthy email threads discussing things sort of contemporaneously, it operates as a meeting. So practically speaking, if Brent says the email, do you approve this? And you as an individual director have a question about it, you can hit the button next to reply all, which is just reply and ask questions about it. Or you could pick up the phone and call Brent to get some clarification on it before you come back and say that you approve it. Questions? Okay, so let me give you the questions that I normally get from my boards. How can we get everything done if we have to wait for a meeting? Well, the answer is if you can't get everything done at a meeting, then you're having problems with your meetings. What about issues that come up in between meetings that need to be addressed? Well, here you clearly have a board delegee or delegees to the management company to assist with that. And if there are consistent issues that come up in between meetings, like payment plan proposals, the board should consider empowering a board member to handle those items. It's interesting because the reality is that before we had email, all the boards of community associations had to make all of their decisions at meetings, right? There was no email thread. And I envision a board president picking up the phone and calling each member, each director saying, we need to make this decision and I need your consent and I need it in writing. And them going from neighbor to neighbor of the directors and picking up documents stating that they were agreeing to take that action. So this is your limitation. If you don't follow this, right, and you have a discussion and there's an argument that that was a meeting and it wasn't open, then there's an argument that the action taken is invalid. And so that's why we want to avoid doing that. Okay, emails, virtually all association related emails are discoverable. We always recommend that boards have a separate association business only email to avoid any work or home emails to be subject to discovery. Plus that way you all can control when you go and check your emails. If it's a dedicated email address just for the board business, say on a regular day, you have other things that you're doing and you say, oh, at 1 o'clock, I'm gonna log into my Gmail account that I have for my board business, and I'm gonna check that email. That way you're controlling it and you can focus on those emails as opposed to having them pop up with all the rest of your emails throughout the day. And the other thing that you should always assume is that all of your emails could be subject to disclosure to all of the members. That's really just more of a best practices in drafting emails. I've been unfortunately involved in some litigation where I've had to redact items. There's only so many things I can redact. And so negative comments about unit owners that were in those emails, unfortunately, there was nothing I could do. And they wound up going out to the subject of those emails, and certainly being in a litigation posture certainly didn't help anyone and the bad blood that had formed between them. So just be mindful about that your emails could be subject to disclosure to all the members. And then that should take you on the straight and narrow and not saying anything that you regret later. Questions? Okay, the last slide. Couple of resources on here, caidc.org, caionline.org. Lots of classes. There are national classes now being offered for free. There are webinars. There's a lot out there. We put on webinars. We put out newsletters at least every other month. You're more than welcome to read them. We try to make sure they get emailed out to everybody, but they're also accessible on the website, I think all the way back to like 2012 or 2013. Questions? Or are you all in a food coma and I just can't see you?
Ursula, there is a requirement, if I'm not mistaken, in Montgomery County for board members to take a certain education course. Does this satisfy that requirement, or do we still have a course that needs to be taken?
Sadly, this does not satisfy it. And sadly, that class can be excruciatingly tedious to go through. It's required of all board members within 90 days of being elected. The original class had, I'm not kidding if I tell you, it had like 350 slides. And getting through it, literally it was everything that came out of the person's mouth was printed on a slide. They streamlined it. They made it a little bit more user-friendly, and they used to allow us to teach it so that we could actually do it in person, which was more interactive than the online recording. And that has all completely halted because apparently some law firms abuse that. And so you have to teach it with the CCOC commissioner, and with COVID, I think they've stopped teaching it at all on any virtual platform except theirs as a recording. So you do need to go take that. I'm sorry, it is a painful class to take, but I certainly make all of our new associates take it because it's got some basics in there. I think you're gonna find that you got more out of this than you will get out of that, but I can't get you around it, unfortunately.
What's the risk of not taking it?
That's a good question. The way they wrote the legislation on that, there's not a lot of teeth to it. I've heard that the chair of the commission has threatened fines for associations where they haven't taken it, but I've never actually heard that the fines were imposed. So I wouldn't be too terribly concerned about it. And certainly to the extent that my firm can offer it again on a virtual platform or live, we would be happy to teach it. And we teach it for free, and it's, you know, much more interactive. So people, I think, get a lot more out of the class because we can talk about things. But I don't know when that's going to happen.
The reason I asked the question is because, to the best of my knowledge, no board member here at Fox Hill has ever taken that course, including those of the master.
Right. Well, it's required. So, I mean, I can't tell you not to take it. That's obviously up to you all.
Yeah.
But it is tedious. So, I mean, I don't want to, you know, say, oh, it's a great class, you're going to love it, because I'm not that kind of person to lie about that to you all. But, you know, you might find some things in there that are helpful as well. So maybe one of you should be the guinea pig that you send off to go take, and they can let everybody else know if they think it was helpful.
Yeah, Carly, you might want to tell Mary Ellen and Russ they have to take the course and see what their response is.
Why don't we make them the guinea pigs?
I like making people guinea pigs who aren't in the room.
Yeah, I have a question about that course. You can't read the text. It has to be instructed by someone. So you have to do it through that tedious time as well?
Correct. Yeah. And I think there's a test at the end, if I recall correctly. Yeah, I won't go too deep into it, but we offer to help develop the course and the materials, you know, since we do board training all the time, and we know what kind of questions boards are asking and things that we're seeing coming up on a regular basis. And, you know, the staff and the commissioners just decided that they didn't want that input. And the result has been a class that unfortunately I think could have been a lot better. I know it's improved from the original iteration, but it's still frankly rather painful to sit through. Don't put that out in this recording, Brent. Stop the recording before I said that. So that's all I have for you all.
Well, that's quite a lot.
I want to go back to the email thing. Ursula?
Okay? Yes?
Uh, I have a lot of email dealing with various Fox Hill issues, but I carefully segregate all my emails into folders or tabs, depending on what platform I'm on, that they are separated from my personal email. Even though they come into a personal email account, they are immediately segregated into groups that are exclusively Fox Hill related. So I'm just wondering, would that meet the requirement?
So I think that's a great practice to do. It's great that you're organized. Really, the recommendation to have a separate email address is more related to a very bad situation where there's litigation and discovery, because lawyers are jerks. And what we do is we then say, we want to take your entire server and have access to it and cull out the emails, because we believe that you're using this email address for personal, but also for the association, and therefore we can't trust that you have appropriately done this.
Okay.
So if you have one email address for the association and we assert that, then that would be the only email address they would have access to, and we would have a good argument that that would be all that they could get access to in the course of discovery if need be. So it's really more of just a best practice in the
Okay.
worst case scenario.
Would that apply also to committees as well as the board?
Correct.
Okay.
Anybody who'd be subject to litigation could
Okay.
be open to that. And I've seen it. I've literally seen them pick up people's whole computer
Okay, thank
and
you.
take it off. So I would just hate for that to happen to somebody.
So I take it from that, we need to do this as soon as possible.
I mean, I don't need you all running screaming from the building worrying about this, but I would recommend that you do it. I think the sooner you get that and have that sort of formal email address in place, the better.
So if you have it in place, I mean, obviously, we're dealing with hypotheticals here, and there was some litigation involved. And let's say we got it in place tomorrow for purposes. Does that then limit any discovery from tomorrow forward that somebody could ask for in event of litigation, or do they still have rights to all the emails prior to our new address tomorrow?
If the emails predating your change in the email address would be relevant to the litigation such that it would be subject to discovery, then yes, they could reach back to that.
Okay. So the sins of the past are with us, basically.
Right. And actually the lesson is just don't get sued.
Yeah, okay.
Anyone else?
So I just had one other topic that it might be useful to hear you on, which is you talk about fiduciary duty, and I think we're all beginning to understand, if not understand, what that means. What about the level of due diligence that a board is supposed to exercise with respect to either financial matters or contractual matters?
So I think that falls into the duty of reasonable care, right? So they're sort of interrelated. The fiduciary duty, you have to act in the best interest of the association, but also the duty of directors of the care and skill of an ordinarily prudent director. And so that means that you be this part about seeking out and using the advice of management, legal counsel, and consultants, as opposed to just trying to do your own thing, especially financially. I have a client that someone on the board thinks that they should take about 20% of their reserve fund and investment in a way that puts the principal at risk. And the auditor has come back strongly stating that's a bad idea. I've come back strongly stating that's a bad idea. And so I think if that board ultimately decides to do that and they lose money in the reserves and they've got to assess because of it, I think they could be looking at some potential problems because they would have ignored the advice that they were given by the professionals. So I think they go hand in hand.
Ursula, I got one more question about this email business. What about committee members and committee chairs? Does that rule apply to them as well?
Yes.
Okay.
I mean, to be completely honest, I hate email. I hate email for so many reasons. You miss tone. You don't get that interaction. People are bad at expressing themselves in the written word. You don't get the full information on it. You tend to just respond to them as they pop up as opposed to thinking about it and having a measured response. And so while I recognize that they are necessary and industry standard at this point in time, they're really just such an impediment that I feel like getting these separate email addresses removes some of those items that are of concern to me, like responding to emails related to association business while you're trying to do something personal. You're not necessarily going to give it the time and the energy that it needs when you can actually go back and look at that email then on your time and your schedule. So that's really a big reason why I think everybody should be on those types of emails. And then if there's some question of what you all discussed on it, it's not a matter of hunting through a bunch of emails. It's looking at one email account and not digging through anything else. And I think that puts you in a better place and gives you some continuity. Anyone else? Okay, well, that's all I have for you all today. Hopefully my first shot goes well today, and then after I get my second shot, I can hopefully actually see you all in person at some point, which would be delightful, because currently you all just look like squinty little figures that are too far away for me to actually identify any of you in a lineup in the future.
But we'll try not to distinguish ourselves.
And I'm going to try to get some artwork behind me. The black that you see back there is an acoustical tile to try to minimize the echo. That is the extent of my stuff in my office currently.
Well,
Thank you,
you
Ursula.
very
That was
much
very
for
helpful.
doing this. And
Of course.
Thank you. Very helpful.
It was nice to meet all of you, and I will send out a package to Brent with the PowerPoint as well as some of the other materials that I indicated I was going to send. And then if this prompts any additional questions or concerns, please shoot them to Brent and then she can get them over to me.
Thank you.
Of course. Thank you. It was nice meeting you all. Have a good day.
Thank you.
Thank you.
Yeah.